Hello and welcome. My name is Yasmine Lupin. I'm a solicitor, a GDPR practitioner, but probably more importantly, I'm a trainer. I enjoy sharing knowledge. Now, I put this webinar together to help organisations start the steps to GDPR compliance. And I've been fortunate to have worked in GDPR compliance, and I've realised there's a big division between the larger organisations implementing the GDPR and the smaller ones. The larger ones had the basic resources to implement the GDPR. However, the small, medium-sized enterprises didn't even know where to start. They didn't know much about the GDPR. The only thing that they knew about were the large fines being up to 20 million euros, which can close any business down. So this is what drove me to actually start this particular webinar, to help them. And it can also help a large organisation fill in the gaps, because I do go through some mitigation techniques. So whether you're a larger organisation or small, medium enterprise, there's no harm in you actually staying until the end. You will get a free GDPR checklist if you stay until the end. I do hope you enjoy the webinar, and thank you for tuning in. Before we start, exciting stuff, a disclaimer. The information I provide you today does not constitute legal advice. If you require legal advice, please instruct a lawyer in your jurisdiction. Today I'm going to provide you with training only. This is an overview of the General Data Protection Regulation only. So what is the purpose of the General Data Protection Regulation? Well, it's all about individuals wanting more control over the use of their personal data. So if an individual parts with their personal data, they need to know how the personal data is being processed, which should be lawfully, how it is going to be kept in an organisation, which would be securely. If it actually leaves the organisation, wherever it goes, are there security measures? If there's no lawful reason to process it, will it be deleted, and when? And finally, if they do exercise their data subject rights, the organisation will be in a position to be able to respond to those data subject rights. So it's all about the individual taking back control. So organisations must process personal data lawfully, and there are risks. The risk could be, if they process the personal data, it could lead to the individual being discriminated. There could be identity theft, fraud, financial loss of confidentiality, and the list can go on. So if the individual is deprived of exercising data subject rights, or processing affects the rights and freedoms of the individual, then they can basically make a complaint to the supervisory authority. And the supervisory authority has the power to fine, and the fines, as you're probably aware, are very high. Up to 20 million euros, or 4% of the annual gross turnover of the organisation, whichever greater, or up to 10 million euros, or 2% of the annual gross turnover of the organisation, whichever greater. So this depends upon the level of the breach. Bad news. There's even more bad news. An individual can claim damages directly against the company, and the damages can be unlimited. And on top of that, the individual can claim compensation. But the bad thing here is, even if the actual fine is minor, it's made public, and the actual damage to the reputation is irreversible and irreparable, because basically customers or clients will probably not part with their personal data. They'll be reluctant to actually give their personal data to an organisation that's been fined. So let's have a look at one example here. Here, the ICO fined Bounty UK Limited £400,000 for illegally sharing personal information belonging to more than 14 million people. So this webinar will go through these 6 steps. Step number 1, does the GDPR apply to your organisation? Step number 2, how do you even start? Step number 3, do you need a data protection officer? Step number 4, which security measures do you require? Step number 5, how can you avoid being fined? Step number 6, how I can help you. So let's have a look at step number 1. Does the General Data Protection Regulation apply to your organisation? So before we can actually answer this particular step, we need to cover quite a few topics: territorial scope, material scope, personal data, key principles, lawful reasons, processing, controller and processor roles. Oh, you're thinking, oh my God, it's far too much for me, I can't deal with it. But don't worry, I'm here to help you. Now let's start territorial scope. So the GDPR applies to organisations operating within Europe outside Europe trading within Europe that offer goods and services within the EU irrespective of whether payment is made, or that monitor the behaviour of individuals within the EU. Now, natural persons also includes non-EU citizens residing within Europe, so be very careful here. If you're processing personal data of individuals that have limited leave to remain or they're asylum seekers, they're still protected under the General Data Protection Regulation. Material scope. Well, it applies to the processing of personal data by automated means. So personal data that's on your computer, your laptop, your iPhone, but also personal data that you can keep on hard copies in your cabinet that form part of a filing system. So they're placed chronologically and you can actually see that the data belongs to specific individuals. Now, there are exceptions and there are also exemptions. Now, if you're processing personal data outside EU law, then the GDPR will not apply. Also, if you're processing personal data purely for personal reasons like texting your friends, corresponding, if there's no business or professional connection, the GDPR will not apply. As far as the Data Protection Act 2018 is concerned, there are a lot of exemptions. So if you're processing personal data for law enforcement reasons, in the interests of national security, journalism, finance, health, etc. The list goes on. It's worthwhile looking at the Information Commissioner's Office website to have an update. Obviously, then it's outside the scope of the GDPR. Every member state country will have their own exemptions, so this is something that needs to be borne in mind. Now let's have a look at personal data. So what is personal data? Well, personal data is data linked directly or indirectly to a natural living person. So yes, we can discount Einstein and we can also discount your pet dog. So now let's give you some examples. So it includes names, email, nationality, any information pertaining to an individual, genetic makeup, voice recording, fingerprints, IP address, images captured on CCTV camera, my photograph, and I am the natural living person. As far as the GDPR is concerned, I am the data subject. Now let's have a look at the key principles. When you're processing personal data, you need to tick the 6 key principles. The first being that you process the personal data lawfully. It has to be transparent and fair. The second one, that you have to make sure when you collect the personal data, you're doing it for a specified, specific, explicit reason. The third one, there is adequate, relevant and limited. The fourth is accurate and up to date. The fifth is kept in a form where the data subject can only be identified for not longer than is necessary. And finally, wherever it is, whether it's on your automated systems like your computer, iPhone, mobile phone, etc., that it's secure, or also if it's in hard copies in your filing cabinets, it's kept secure. Now, sometimes people also refer to what we call is the 7th principle, but this is all about basically the controller being accountable, and we'll look at controlling and accountability further on in the webinar. Now let's go back to key principle number 1, finding a lawful reason. If you do take personal data, make sure that you can justify why you're taking it. You may need the consent of the individual. You may need it for contractual reasons, a legal obligation reason, to protect the vital interests of the individual or a third party, for public task reasons, for legitimate interest reasons. So whatever you do, make sure you can justify it. You may also be collecting special categories of personal data. This is personal data which relates to race, ethnic origin, political opinion, affiliation, religious or political beliefs, trade union membership, genetic, biometric data, health-related, sex life, sexual orientation. A lot of organisations say to me, well, I don't think I actually do take any special categories of personal data, but think again. If you're taking copies of personal passports, for example, for ID purposes, this is special categories of personal data. Any information you require in order to meet your illegal obligation, for example, equal opportunities policy, then you obviously need to comply. And you also probably do take health records if you have employees. If this is the case, then please consider Article 9.2 because the lawful reasons slightly differ. Now let's have a look at processing of personal data. So what is processing? It means any operation or set of operations performed on personal data, whether or not by automated means. So if you collect the personal data and you do nothing with it, you're still caught by the General Data Protection Regulation. So you may put it in a filing cabinet, in files, on your automated systems, your mobile phone, a recording. The GDPR does actually go into detail and provide you with examples of processing, some of which can be storage, adaptation, alteration. These are the lists. So if you're doing any of these, and also if you're just collecting basically the personal data, then you are caught by the General Data Protection Regulation. So what do we mean by controller? So this is your office, and it's a lovely one too, and you process your customers' personal data. As far as the GDPR is concerned, you are accountable because you determine the purposes and means of processing the personal data of your customers. You need to make sure that you process the personal data in line with the key principles. A controller can be a natural person or legal person, a public authority, agency that can act alone or with others jointly. So what do we mean by the processor? So you as a controller decide to transfer your customers' personal data to an independent organisation outside your particular organisation. In this particular case, the accountancy company would be what we call the processor. They would need to act on the written instructions of you, the controller, as far as processing the customer's personal data is concerned. And this is why we need what we call a controller-processor contract. This is here to protect the controller, to mitigate. So the actual processor only processes the personal data of the customers in line with your instructions. Now, quite often the processor will also store the actual customer's personal data on a sub-processor. So if you do have a contract, also take into consideration the sub-processor. In both cases, the controller must make sure that the processor is GDPR compliant and also Happy Cloud is GDPR compliant. So what happens if the processors are based in the EEA and third countries? So here again, this is you transfer your customer's personal data to France, New York, Uruguay, China. Now, as far as France is concerned, the European Commission considers this country secure simply because it's within the EEA. As far as Uruguay is concerned, it's on the adequacy list, so there's no problems here. If you are transferring any personal data to an organisation in America, you need to check if they have the privacy shield. If they do not, as with China, make sure you have appropriate safeguards in place. There are exemptions, there are derogations. If you have a group company, then consider binding corporate rules because this helps the flow of information within the group company. So does the General Data Protection Regulation apply to your organisation? Well, yes, it will probably apply because you probably don't fall within the exceptions, not even the exemptions. However, please check. Now, if you are an individual and you determine the means and purposes of processing personal data and you're not doing it in a personal context, more likely in a business or professional context, then you are still the controller. Even if you're not a company, but you're an individual, you are the controller and therefore you're held accountable. Remember, you can be a joint controller, but you cannot be a joint processor. In certain circumstances, an organisation can be a controller and processor, but not for the same set of personal data. Do you need a data protection officer? Well, the simple answer to that is no. Unless you're a public authority, there is an exception, however, courts acting in their judiciary capacity. You will also need one if you're executing large-scale systematic tracking of individuals. This is where you're monitoring individuals online. You will require a data protection officer. if you're executing a large-scale processing of special categories of personal data or data related to crime. So basically, if you're a hospital or a university, you'll definitely need a data protection officer. Now, if you do choose a data protection officer, make sure they have a good knowledge of the General Data Protection Regulation, working knowledge of security systems, time to perform their tasks, the resources. You can take somebody on internally, you can train them up. However, be very careful not to choose someone who works in IT or finance because there's a conflict of interest. You can also take somebody externally, take somebody up on part-time or full-time. Member state countries will have different or additional requirements. The most important aspect you have to bear in mind here, the data protection officer will not be penalised for the activities that it does. The controller is still held accountable. Step 3, how do you even start? Well, the first thing you have to do is an information audit. This is all about assessing the personal data in your organisation and seeing whether you tick the 6 key principles. Another thing you should do is a data mapping exercise. This is all about understanding how the personal data comes into your organisation, where it sits and how it leaves the organisation. And if you're going to process personal data which is considered high risk, you should do what we call a data protection impact assessment. But be very careful, you're supposed to get the supervisory authority's approval first before you actually process the personal data. Step 4, security measures. Now, with regards to security, when it comes to the GDPR, you need to implement security measures appropriate to the risks. You might find the actual security you have is sufficient. However, if you do have health records or copies of passports, then make sure these documents, because they're special categories of personal data, they're encrypted, or you have implemented pseudonymization. This is absolutely important. Also, training is very important. Your staff need to be trained. They need to be trained that basically paper files are not left on the desk, everything is locked safely in a cabinet. Make sure you limit access. So security is about everything, not only basically the personal data that's stored on your computers, your laptops, mobile phones, etc., but also hard copies. Remember that when there is a breach, there's going to be a problem, and quite often it's because you haven't trained the staff to understand what to do, or you haven't implemented the correct security measures. Step 5, how can you avoid being fined? You can actually reduce the chance of being fined, but you need to demonstrate to the supervisory authority that you've done everything with regards to GDPR, that you have policies and procedures in place, that you've trained your staff, you know about the security measures. It's ongoing. GDPR is ongoing, and you monitor it on maybe a quarterly basis. This is very important. A lot of organisations come to me and they say, well, Yasmine, I want to be GDPR compliant, so can you help me with my privacy notice? And I tell them very clearly, that's not enough. Just having a privacy notice on your website is not going to make you GDPR compliant. You need to be in a position to understand how to actually respond to data subject rights. You need to know wherever the personal data is it secure? Also, do you have controller processor contracts executed? So this is very important. It's not just about a privacy notice. One document is not going to make you GDPR compliant. The more things you have in place, the better it is for you. And hopefully the GDPR checklist that I'm going to provide you at the end of this webinar can only help. Yes, the GDPR checklist has arrived finally. So let's start. Do you need a data protection officer? Train your staff. Remember, 80% of GDPR breaches occur due to human error. Carry out an information audit and data mapping exercise. Make sure you have the policies and procedures in place. You need a retention policy. You need to know how to deal with data subject rights. You need a subject access request policy, and I can actually provide you with all of these in my GDPR toolkit. Make sure you have systems in place to detect, investigate personal data breaches. If you're transferring personal data out of your organisation, execute controller processor contracts. Remember, if it's third country, think about the adequacy list. If they're on the adequacy list, then that's fine. If not, make sure you have the appropriate safeguards in place. If they're group companies, consider the binding corporate rules. You need to ensure that you have security measures implemented appropriate to the risks. If you have special categories of personal data, consider encryption and pseudonymization. Cyber Essentials is something that I've actually noted down. It's a useful framework. A lot of organisations do implement this. It's not the only thing you have to do. You still have to tick the other boxes. And finally, the exceptions and exemptions. Unfortunately, this brings us to the end of the GDPR webinar. Yes, I know it's difficult to part. However, please keep in touch. If you haven't jotted down that GDPR checklist, please send me an email quoting basically the code 204204, and I'm happy to send it back to you. Obviously, remember, you can start the steps to GDPR compliance by buying my GDPR package. The offer still opens. This way, I can continue to help you become GDPR compliant.